Hey everybody, thanks for joining me once again for another edition of Will Wednesdays. I'm your host, Greg Davis with Tri-City Lawyers here in Durham, North Carolina. This week's topic is, should I update my estate documents if and when I move to a new state? But first, a brief disclaimer. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for general informational purposes only. Viewers of this presentation should contact their attorney to obtain advice with respect to any particular legal matter. No reader, user, or browser of this presentation should act or refrain from acting on the basis of information in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. This came up recently. A client of mine here in North Carolina moved to another state, and they said, "Hey, Greg, should I update my estate planning documents?" And for them, we did the full will package. We did the will, general power of attorney, healthcare power of attorney, and their living will, also called the healthcare directive. Now, number one, you definitely want to update your documents when you move to another state. Why? Number one, there are differences in tax aspects and in state law. So, for example, one thing that comes to mind immediately is estate tax. Now, certain states like California and North Carolina do not charge estate tax at the state level, but other states like New York do charge estate tax. So you definitely want to know that before you move from one state to another, because that could have a significant impact on the amount of money you have to pay in estate taxes. You want to establish your legal domicile, and by updating your estate planning documents, that's one sign that that is taking place. And this is very important when it comes to filing income taxes. So for example, let's say you're moving to a new state, but you're retaining your residence in your previous state. To show the tax man, the tax collector, the tax person that you are making your new state your legal domicile, one way to do that is to update your legal documents. The third reason to update your documents is the question of honoring your powers of attorney. Now, properly drafted documents in one state should and will transfer over to another state. However, when you move to a new state, it might take more time. Those other states, for example, if it's drafted in North Carolina, you move to another state, other states can look at those powers of attorney related to your healthcare or your general power of attorney related to your finances, and they're going to be under a stricter level of scrutiny. They're going to analyze them more thoroughly, and it's going to slow down the process of them being accepted as your true legal documents. Therefore, it's just much easier to update those powers of attorney when you move to a new state. Bottom line, if you move to a new state, you definitely want to update all of your estate planning documents: your will, your general power of attorney, healthcare power of attorney, and your living will. This has been Greg Davis with Will Wednesdays. As I like to always say, everyone has an estate, but not everyone has a plan. I'll see you next Wednesday. Thanks for tuning in.